Can a school tell the student what they can wear and what they cannot wear in the name of uniformity? Where does the religious freedom end and the institutional discipline begin? And what exactly the Allahabad High Court has told about wearing hijab in schools? Hello everyone, welcome to Ajram and Ravi's Flash News. My name is Shubhangi Singh, and in today's session we are going to discuss and understand in detail that what exactly is the verdict and the statement that Allahabad High Court has given for student wearing hijab in schools. So when we look at this present news, the first thing that you need to understand here that there has been no ban on hijab at all. The point that needs to be understood clearly here that High Court is saying that wearing hijab or scarf, that is not part of essential religious practices related to Islam, and that is why it is not something that can go against the uniformity that should come with a school. Now before moving further, we have to understand that what this was case. So this was a case by class 11 student who was wearing a hijab and was denied by the school in the name of uniformity, that the uniform standard rules are established, and the petition was filed. Now the petition here was a writ petition. Can you tell me in the comment section how many types of writ petitions are present there? Now Allahabad High Court in their judgment has dismissed the plea, very clearly saying that when we are talking about school uniform, that has to be uniform, it has to be bona fide, and it has to be non-discriminatory. In this context, wearing hijab or anything of that sort is going to change the nature of uniformity. Furthermore, when we are talking about wearing of hijab or a headscarf, this is not part of essential religious practices. So, where we are talking about Article 25, the fundamental right, we cannot make the judgment just based on that. And third, they have also clarified that a student cannot unilaterally, just from their end, change the institutional dress code. So, all in all, the plea has been denied and the reasons have been laid out very clearly. But it does raise a lot of questions about religious freedom that is given by Article 25. And where do we get to see that institutional discipline comes into the picture? Now for this we are going to dive into the details. Now the first thing we have to understand that why exactly the court took this stance. I have briefed you out, now let us dive into the details. So the first thing that you have to understand, court is saying that uniformity is extremely important for institutions such as school. That means same dress code should be present for all students. Now why this is important? This is important because this promotes equality, it promotes discipline, and it also ensures that the institutional identity is maintained. Second, when we are talking about uniform, this is also one way of ensuring that a religious neutral environment is present. That is why institutional identity is important, which also helps in regulating discipline. And third factor which I have just talked about, that is essential religious practice test. Now there has been no sufficient proof for the High Court to believe that wearing hijab is an essential religious practice. How do we understand this better? First, let us understand that what is the doctrine of essential religious practices. Now this doctrine is one of the most fundamental basis on which court decides that if this practice, if any practice is extremely fundamental and integral to a religion or not. If it is integral, if it is fundamental, that is when we get to see that the provisions of Article 25, the protections given by Article 25, they come into the picture. But if they do not, then you have to remember that our constitution promises secular nature, then that will be focused upon. So, essential religious practice test is basically a way to identify that what is the scope of constitutional protection. where the constitutional protection needs to apply and where we need to focus on fundamental rights. Now, many of you might be thinking, ma'am, fundamental rights, that cannot be compromised. For that, you need to remember that fundamental rights are not absolute. So, the given practices which are passing the ERP test, which are fundamental integral, they will get the protection of Article 25. The rest will have to fall in the other ambit. Now, this is something, ERP test is something fundamentally very important for a country like India, because you have to clearly understand here that when we are looking at religions, this is where we get to see diversity, correct? But at the same time, when we are looking at our constitution, as I just said, it is secular. Now, the distinction that needs to be drawn, for that it is very important. For a country like India, which has a constitutionally secular society, in this context, it is very important that ERP comes into the picture, because this is what that can balance that where does individual religious freedom lie, where equality and social reform can come into the picture, when we are talking about institutional regulations, how they need to be placed, what to do with and how to execute public order, morality and health. But at the same time, ERP remains one of the most controversial aspects, because the determination of essential religious practices, that lies with the court. So, earlier also we have seen courts determining that these religious practices lie out of the ambit of essential religious practices. Can you tell me in the comment section a few examples of that which we have seen previously? Now that we have understood what exactly the High Court has said, why exactly the High Court has said, another important thing from this very lens that becomes important here is that what High Court has said is not something new. The previous judgments is something that have been on the similar line. The legal position is still not finally settled, especially by Supreme Court. Why I am saying specifically by Supreme Court? That because that is the highest order of verdict that we can see, or a settlement of an issue that we can expect. But previously, Karnataka High Court in 2022 itself clearly held that hijab was not an essential religious practice, and in this judgment as well, Allahabad High Court did say that we do not see any reason to go away from the judgment that the Karnataka High Court had given. Supreme Court that very year, they gave a split verdict. That means there were votes which were in different numbers. Split verdict. That means there was no final authoritative settling of the issue. Apart from that, Kerala, Bombay High Court, they have already considered that the right of educational institutions to enforce a uniform, a prescribed dress code is absolutely present, and on the similar lines, this year again we are seeing the ruling of Allahabad High Court. Now, this is where a lot of contention, especially because of religious sensitivities, does arise. But as I have previously also explained, that when we are talking about fundamental rights, even this petition, this plea that was filed, this talked about that we have our right to equality, freedom of expression and freedom of religion. This was the students' claim as well. But at the same time, as I said, that fundamental rights are not absolute. There can be restrictions that can be placed, and the court has also given the very same reasoning that the restrictions may be constitutionally valid if uniformity is present, if the dress code is bona fide, if it is non-discriminatory, and if it is related to institutional identity. So, this is where we have a clear line drawn by the court in this context, that when we are looking at institutions, schools, this is where we do not want to create religious identities, we want to keep it neutral. This is something that is personal and it shouldn't come into the way of education or institutional discipline itself. Now, what are your thoughts on this? Let me know in the comment section, because this debate has two big sides. On one side, what do we see? We see the individual religion. We see that individual autonomy is this, religious identity is there. But on the other side, we have institutional discipline, we have a common secular space, we have a constitutionally secular society. So the order to balance it is something very difficult, and our nation has been trying for very long. Hopefully that will be maintained, that will be ensured. All in all, we conclude with the bigger question here that this case is not just about a school uniform. This case is about who decides that what is essential for a religion, who gets to decide who will wear in secular spaces, and most importantly, where should the institutional autonomy end. Again, if you have any answer to these questions, I'll be waiting for your comments. I'm leaving you here with 3 prelims practice questions because very intricately related to polity. Direct questions can be expected out of it. So this is the first question, this is the second question, and then I have this as the third question. All 3 questions were covered during the session. I hope you have their answers, so let me know them in the comment section. That was all. Thank you so much.